It is my pleasure now to introduce our faculty director and today's lead conference organizer, Blake Reed. By way of introduction, Blake researches and teaches in the areas of telecommunications, internet, copyright, and disabilities law. For the past decade until this year, Blake has directed the Samuelson Glushko Technology, Law, and Policy Clinic, the TLPC at Colorado Law. For those of you who are not familiar with clinics, they are the labs of the law school. This is where law students do real work for real clients in the real world. Actually, I launched the Technology, Law, and Policy Clinic, and Blake was a star student himself in that clinic back in the day. Indeed, he secured an exemption for security researchers as part of the triennial review in front of the Copyright Office back in the day. When Blake took over the clinic, he didn't just keep it going, he dramatically improved it from the days in which I led it. His student attorneys conducted technology policy advocacy in the public interest before an array of government bodies ranging from agencies, courts, legislatures, and others. And along the way, Blake found time to write, and he has become a very accomplished scholar in addition to an accomplished teacher. In fact, Colorado Law just put him on the tenure track faculty this year. His work has been published in the Stanford Law Review, California Law Review, and Indiana Law Journal, among others. He's the lead organizer for today's conference, and we are in for a terrific set of discussions. Please help me give a warm welcome to Blake Reed.
Good morning. It's a privilege to welcome you to Silicon Flatirons. Before we begin, I want to thank all of my colleagues on the Silicon Flatiron staff who worked so hard to pull this event together. In particular, I want to thank Shannon Sturgeon and Nate Mariotti for organizing the logistics of the event, both for everyone here in person and for the folks who are joining us online. Christine McCloskey, who helped bring in our outstanding group of speakers from all over the country, and Sarah Schnick-Grund, who has helped in many ways to bring our students into the mix for this event. Please join me in giving them a hand. All right, with that, I am delighted to welcome you to our second conference this year on generative AI. It's an outgrowth of my colleagues and fellow faculty directors, Margot Kaminsky and Harry Sturgeon's AI Ethics series. My thanks to them for laying such a wonderful foundation for our conversation today. And this is kind of a spiritual successor to the work of our former Silicon Flatirons colleague, Cristelia Garcia, who's now out at Georgetown Law. We're really excited today to focus on the intersection between generative AI and copyright law. And I want to do a little table setting and then introduce our keynote speaker. So almost as quickly as generative AI tools like ChatGPT and DALL-E burst onto the mainstream this spring and promised radical changes across a wide range of society, they encountered the legal system. And the first contact with the legal system, at least here in the United States, was with copyright law. Now, my normal remit here at Silicon Flatirons is leading our telecom and platforms initiative. And you may be used to Silicon Flatirons doing a lot of telecom-focused events and wondering, what does generative AI and copyright have to do with any of that? And the answer from my perspective is that the evolution of AI and its intersection with the legal system raises profound, descriptive, and normative questions about the future of the internet and the flow of digital information that warrant attention not only through the lenses of copyright law and AI policy and regulation, but also through Silicon Flatiron's broader lens on the migration to and the evolution of digital broadband networks, platforms, and applications. And that's what we're going to try to do today. So as one commenter has described it, copyright law is a durable creature of technology regulation that predates the internet by many centuries. We're talking about the Statute of Anne and the stationer's monopoly at our student primer event last night. Copyright law is often the primary and only functional law of the internet. So unsurprisingly, an internet technology taking the world by storm has attracted substantial attention from litigants, policymakers, and technologists who are trying to construct generative AI and its future trajectory through the lens of copyright law. So in today's conference, we're going to try and make sense of the intersection of generative AI and copyright from two different angles, law and policy. On the legal front, we've got high-profile lawsuits from artists, coders, writers, photographers, and industrial rights holders centering on copyright and related claims that are starting to pile up in the federal courts over the past several months. There's questions about how copyright law's basic rudiments of infringement and fair use and how they map onto generative AI's complex supply chain and mechanics, and whether the outputs of AI systems are eligible for copyright protection. And these questions have roiled scholars and litigators, government and civil society alike. Our first panel, led by Harry Surden, is going to explore these topics with a group of distinguished experts and shed some light on the doctrinal state of play. And then from a policy perspective, what to do about all of this raises a whole new set of vexing questions about whether and how copyright law should change in response to generative AI's technological, social, cultural, and economic impacts. And we'll discuss that in the second panel. So more broadly, questions about whether copyright is the or even a correct lens for shaping generative AI policy, and how copyright intersects with broader agendas about the policy around and the regulation of AI, both in the US and internationally, including on issues ranging from privacy, security, transparency, accessibility, competition, consumer protection, discrimination, mis and disinformation, labor and employment. We'll try and tackle all of that today. And against that backdrop, I could not be more excited to welcome our keynote speaker, Maria Strong, the Associate Register of Copyrights and Director of International Affairs for the United States Copyright Office, which is part of the Library of Congress, responsible for both administering the registration system for copyrighted works and advising Congress on copyright law and policy. Maria is going to share the range of activities that the office is undertaking right now in this space. I'm especially excited for us here in Colorado. There's an exciting decision about the winner of the Colorado State Fair's annual fine art competition in 2022, Theater de Opera Spatiale, which was recently denied copyright protection. We'll hear all about that. In her role as Associate Register, Maria advises the Register on the policy functions of the office, including domestic and international copyright issues. She directs the Office of Policy and International Affairs. Maria has also served as the Acting Register of Copyrights back in 2020, has served at the Copyright Office since 2010, following nearly 2 decades stint in private practice, and very close to our hearts here, started her career at the Federal Communications Commission. Without further ado, please join me in welcoming Maria Strong to Silicon Flatirons.
Thanks, everybody. Thank you, so much for the invitation. It's a pleasure to be here in beautiful Boulder, and I almost didn't make it thanks to the government shutdown drama of last week, and I really want to thank Professor Reed, Executive Director Bernthal, and the incredible staff here to make sure that I was able to literally catch a last-minute flight and be with you today. It is a pleasure. As Blake said, we're here today to talk about the many issues that have come out of the intersection between copyright and AI, including generative AI. A lot has happened in this space over the past year. Members of the public are now using, sophisticated AI, generative AI systems to produce their own, images, art, visual works, the classic subject matter of copyright. And, creators have become very vocal in the press, on the Hill, in the courts, about their concerns on their work being used and the outputs and how that affects their livelihoods. At the same time, others are also expressing a lot of interest and excitement about the possibility of how these tools might assist them in their creativity. Hence, you can see the opportunities and the challenge. I will caution everybody, it's a very complex ecosystem. It's not binary, and I think that's kind of a challenge for policymakers and lawmakers as we move forward. My goal this morning is to provide an update, sort of set the scene on what the Copyright Office has been doing in response to all these developments. So let me sort of start at the start, which is to remind everybody the role of the Copyright Office. We are part of the legislative branch of government, and we're situated within the Library of Congress. We are the agency that administers the copyright registration system. And although copyright registration, as you know, is no longer required for protection, registration does confer a number of benefits, including the ability to bring a copyright infringement in federal court. Each year, we issue about 500,000 registration claims covering millions of works. But we do more than that. Congress has also told us what it wants us to do. And we are the Congress's primary legal advisor on copyright. It's sort of like having 535 clients at once. We do work closely with congressional offices on domestic copyright legislation and policy matters, including by providing, technical advice on their proposals. Some of those proposals might not see the light of the day, and some of those proposals we may or may not be consulted on. So there's, Washington, D.C. is fast moving at the same time as sometimes slow moving, and we're trying to react and serve, our congressional clients. We also conduct comprehensive policy and legal analysis for Congress for use by the public, Congress, and often the courts. To be clear, when it comes to advising the president and the executive branch, it's the U.S. Patent and Trademark Office that has that primary lead. When it comes to litigation, we work with the Department of Justice and the Solicitor General as they represent our agency and all agencies before the courts. And they, in turn, work closely with us on those copyright cases that might come before the Supreme Court, as we have seen in recent sessions and terms. On international matters, our office participates as part of an interagency team, and that's usually led by an executive branch agency. So, for example, when we review copyright legal developments in another country or developments in something like APEC or OECD or the G7, we are part of a team that is evaluating the copyright interests and equities in that development. But to be sure, who the final decision maker in that is going to be an executive branch agency, depending upon the issue at hand. Click, there we go. So let me share a little bit about what we've been doing the past probably almost a year. We have been very active in response to the development of AI and in particularly generative AI. Earlier this year, we announced a formal launch of our AI initiative, which comprises of a number of pieces of actions, kept us incredibly busy. We have provided, for example, and I'll talk about this in a minute, guidance on how to register works that contain AI-generated material. We've held public roundtables with AI developers, artists, academics, business people, and everyone else interested in the intersection of AI and copyright. We've had meetings with dozens of stakeholders, and we provided 2 educational webinars on both registration and international matters. All of this is on our website. We are a very transparent agency, and that's why we like to, gather the information in a diligent, thoughtful way so that we can make sure what we have on the table as we provide the advice that we are going to be doing in the future. All this led up to, at the end of August, we issued a formal notice of inquiry, sometimes called an NOI, where we are seeking public comment on a number of questions that we have identified. And I'll get to that also in a little bit. Already, we've received close to 8,000 comments that have been put in well in advance of the deadline. So this level of interest is not surprising. These issues are not just technical, but they're actually existential to many creators. These issues touch on the fundamental nature and future of human creativity and how it can coexist and interact with potentially unlimited technological capabilities. And so the office's foray into the current AI technology has involved copyrightability of the output of AI systems. This is a function of our role in registering copyrights. While we don't investigate the underlying facts set out in an application for registration, we do review the deposit copy of the work to make sure it's copyrightable. And so a few years ago, we actually started receiving applications to register works creating generative AI. So this is not new to us. This meant that early on, we had to make decisions and take some public positions before other agencies in our government, before other countries have started to develop things. While there are other countries around the world that do have registration systems, I think ours is probably the oldest and most robust. I'll just acknowledge my little confirmation bias there. So why don't we take a look at some of the registration decisions that have come down out of our office. So the first one, as you see on the screen, involved a claim that we received back actually in 2018, and it was essentially a test case. It's a work of visual art that claimed to have been created entirely by AI, allegedly with no human involvement. This work is called A Recent Entrance to Paradise. The applicant, Stephen Thaler, identified the author as the creativity machine, and he himself as the copyright claimant by virtue of being the machine's owner. He described the work as autonomously created by a computer algorithm running on a machine. So when we were examining this claim, we weren't working from a blank slate. As far back as the late 19th century, courts have been looking at the scope of copyright in works created using machines, starting back with the camera, looking at the reference to authors in the Constitution, as well as language in the Copyright Act. Courts have concluded that human authorship was required for copyright protection. They've rejected copyright claims, for example, in a selfie taken by a monkey, and in a book purported to be authored by non-human spiritual beings. The question in each case was whether the work reflected the human's creative choices, even if the machine was used as a tool. So applying these well-established principles to Mr. Thaler's claim, the Copyright Office's review board refused registration. Thaler then sued in federal court because a review board is final agency action. And he sued arguing that the Copyright Act does not explicitly restrict copyright to human-made works, and that any ambiguity should be resolved in favor of protection in order to encourage maximum creation and dissemination of works, for the public benefit. In August, just 2 months ago, the U.S. District Court for the District of Columbia, in the case of Thaler versus Perlmutter, issued a decision agreeing with us. It held that human authorship is an essential part of a valid copyright claim. Mr. Thaler has said he's going to appeal. Now, the Thaler case involves a clear and straightforward set of facts on authorship because he maintained that the work was created entirely by AI. Other applications that we have received are presenting more challenging questions. What about works produced through a combination of human and machine creation? What type and amount of human contribution is enough to merit copyright protection? So another case has involved this graphic novel called Zarya of the Dawn, which included text written by the human applicant, Chris Castanova, and visual images generated by the AI technology Midjourney. When the office learned that the images had been created by AI, we sought more information from the applicant. And that's called correspondence, where our examiners go back and forth with the applicants to better understand the scope of the claim. As a result, we ended up proposing, canceled the initial registration. In its place, we issued a more limited registration that covered only the human-authored elements of this work, and that is the text, as well as the selection, coordination, and arrangement of the texts and images. We excluded from the scope of registration the AI images themselves because they lacked human authorship. And I really invite you to read our letter on that so you can really understand the scope of the work we did to understand what was being claimed. So, the rapidly growing use of AI and the attention generated by some of these cases, like Recent Entrance to Paradise and Zarya of the Dawn, meant that the Copyright Office began receiving requests and questions for further guidance on how do applicants file claims for copyright. And to address the copyrightability and registration issues raised by these questions, on March 16th, we issued registration guidance, which confirms the requirement of human authorship and instructs applicants to disclaim AI-generated content in their works if it is more than de minimis. So what does that mean? So what it means is that the question to ask is, would the human-generated material, standing on its own, be copyrightable if it had been created by a human author? If so, then a very brief description statement disclosing the work includes AI material should be included in the application for registration. This is very similar to our long-standing requirements to disclaim copyrighted material owned by others that has incorporated new work, or you have to disclaim if you're using public domain work. It helps to identify the scope of what is being copyrighted for the public record. So our goal, to be clear, is not to set up barriers to registration, but rather to help people avoid problems, such as maybe later questioning about the validity of the registration by third parties or by the courts. We do expect to further develop and refine this guidance, based on the comments we've been receiving over the last couple of months that we've been engaged in this, as well as our continued review of applications involving AI. As an aside, I would say maybe you would think, well, wow, with all this, you guys are getting tons and tons of applications. And actually, we're not. And we only have a little over 200 applications for claims that involve AI generated material right now. So I think people were expecting a lot more. Obviously, I think another thing to keep in mind is that technology is constantly changing. So everything I say today is as of the state of technology today. We have also, been working on trying to address even more questions we've received from the public about this guidance. So on June 28th, the office hosted a public webinar to discuss that guidance. The head of our registration program went through a variety of potential hypotheticals, provided examples, and answered questions. It's also available online right now. I think a lot of initial feedback we've heard is that people are finding that webinar very helpful. So, I think there are also going to be a lot of cases where content creators are going to want to register works creating the AI generated material. I mean, that is the big question of the day, isn't it? So how it would work would be let's say an author uses AI to brainstorm a plot and characters, but then writes her own book herself and omits any of the AI generated material in that book. In this case, there's no need to disclose or disclaim anything. But if the author wrote the text herself and included illustrations generated by AI, like the Casanova case, Aria of the Dawn, that she's going to need to check on the box in the registration form that she is excluding that 2D artwork, or else provide a very brief statement in the application explaining the role of AI in her work. And the webinar goes through the examples. I just want to reiterate, we're not looking for an Excel sheet that says every single thing that you did. We're looking for some basic guidance so we can examine, and if we choose to, our examiner can engage in correspondence to understand the scope of the claim. I think Blake mentioned a little bit on this very important case. The most recent example of complex registration claim came last month when the office's review board upheld a refusal to register the work of a visual art called Théâtre d'Opera Spéciale, which was created in Midjourney by an artist named Jason Allen. And this case is the one that is probably familiar to folks here in Boulder, as it won the 2022 Colorado State Fair's annual fine art competition. As you can see on the slide, the initial image generated by Midjourney is on the left, and the work that Mr. Allen sought to register with us, the deposit copy, is on the right. When the registration claim was originally submitted to us, there was no mention of the work having been made or based on Midjourney. But because of the national headlines revealing that AI contributed to this work, our examiner requested additional information from the applicant. And in response to our questions, Mr. Allen stated that he input numerous reversions and text prompts of at least 624 times to arrive at the initial version of this image. He also explained that he used Adobe Photoshop to remove flaws and create new visual content, and he used gigapixel AI to upscale the image, increasing its resolution and size. At the end of the day, Mr. Allen declined the examiner's request to disclaim the AI-generated aspects, and he reasserted his claim to the copyright in the entire work. But the office concluded that the work could not be registered unless the claim was limited to the authorship that the human author himself contributed. And consistent with our registration guidance, the office accepted the claim that the human-authored visual edits made with Adobe Photoshop were de minimis and did not need to be disclaimed. But the more extensive features generated by Midjourney and Gigapixel AI needed to be excluded as non-human authorship. The application brought the case to our review board, which is, as I mentioned, so next level of appeal. And the board affirmed that Mr. Allen could not be considered the author of the initial image since his sole contribution was inputting the text prompts that have produced it. Because this AI generated material, which could not be protected by copyright, was more than a de minimis contribution to the work, it needed to be disclaimed. In the board's view, even though Mr. Allen described the text prompts that he took to produce the image, the resulting image was entirely dependent on how the Midjourney system processed those prompts. The review board opinion points out that Midjourney does not understand grammar, sentence structure, or words like humans. Bottom line is, if Mr. Allen were willing to disclaim the AI-generated material, he could file a new application and explain how his modifications to the image rose to the level of copyrightable authorship. So as I mentioned at the start, our office does do more than registration. We also look at the larger law and policy issues and the policy implications of copyright and AI. And we are asking a lot of questions. And today I'm going to have a lot of questions. And since the review is open, I'm not going to have a lot of answers to these questions. And I'm looking very much forward to the discussion later. On the infringement side, we're seeing more and more discussion of the legal implications for the incorporation of copyrighted works into the training of large language models. This is the ingestion issue. And this includes several high-profile lawsuits that have been filed by copyright owners, also mentioned, I think, by Blake early on. There's a large number of questions, and we're trying our best to explore many of these through our notice of inquiry. So, for example, does employing copyrighted materials to train generative AI systems constitute infringement? And if so, under what circumstances? Do uses require consent and compensation from the copyright holder? Or do they qualify as fair use? There is considerable debate over how existing case law applies, notably the Second Circuit's decision in Google Books and the recent Supreme Court case in the Andy Warhol Foundation versus Goldsmith. If consent or compensation for training is required, how can this be feasibly accomplished given the volume of works, ingested? Could this be done, or should this be done through direct licensing, collective licensing, or some form of compulsory license? Our current copyright system incorporates all three models in various other contexts, and I think we're all kind of blown away by the scale of AI, and that is a major factor to consider going forward in any solution. As a practical matter, how can copyright owners find out whether their works have even been used in the machine training? What information about the process is retained by the AI developers? And what level of public transparency is appropriate, feasible, or desired? If copyright owners are given the ability to either opt in or opt out in having their works included in training materials, how's that going to work, especially for individual creators? Also, is it even consistent with copyright law to require owners to opt out of the unlicensed use of our systems? Who should be ultimately responsible for infringement, either during the training process or for the ultimate output? The assembler of the training material, the entity offering the tools, the user of the tools? Besides authorship and infringement, the final major area of question in our notice looks at the boundary between creativity and personal identity. Performing artists in particular have raised questions about AI-generated work imitating their likenesses, their voice, their style. We've all seen reports of, deep fakes, AI-generated works, that purport to be the Drake and the Weeknd and other examples. And so while current copyright law does not reach this activity, there are various state laws involving rights of publicity, unfair competition, misappropriation that might apply, but it's very mixed across our country. And how are these laws going to address the new technologies? So, take a deep breath. That's a lot of questions. Believe me, our notice went through a lot of internal edits just to get to the 34 numbered questions that we have disclosed to the public. We want to find a way or ways, forward that ensure that human creativity can continue to thrive, but it also that promotes rather than inhibits the development of this exciting technology. So I've spent most of my time right now on what the office is doing, but as we know, AI raises more issues than just in the copyright basket. Things like bias, access to public data, transparency, cybersecurity, competition, all those very important issues are kind of outside the scope of my lane. And so there are other agencies that are looking into that. There are also members of Congress who are in various subcommittees that are looking at issues as patent inventorship, competition, security, election safety, national defense, among others. There have been, copyright hearings held in both the House and the Senate. Senator Schumer has his SAFE AI Act, it's called the SAFE AI Act Innovation Framework that he announced in June, and he has plans to hold some insight forums on various issues, over the next couple of months or so. It hasn't really been rolled out yet. Other members of Congress are also looking at various angles of AI. In addition to Congress, back to what I said at the beginning, there's other agencies looking at AI as well. So for example, the US Patent and Trademark Office has work streams on inventorship issues as well as standards. The relatively new National Artificial Intelligence Advisory Committee, commonly called NIAC, which was established by the National AI Act of 2020, they advise the president and the National AI Innovation Office. The Federal Trade Commission just held a roundtable public session on generative AI 2 days ago. The White House has its blueprint for an AI Bill of Rights. NIST has its AI risk management framework. NTIA is working on its AI accountability policy. So you can see everyone's interested in AI. We are also keenly aware about the global nature of generative AI. We can't confine our attention to US borders. And since AI systems are developed and deployed internationally using content from around the world, we need to be aware of developments globally. And so my office is speaking with copyright policymakers in other countries about their approaches, specifically and especially on the authorship issue, registration, copyrightabilities, because that's clearly in our bailiwick. There is a lot of interest on what we're doing in the United States because our office got so far out in front. We have a registration system and we play a major role, especially in advising Congress. And so I will say why there seems to be widespread agreement across borders that copyright requires human authorship, that is by no means absolute. There are other jurisdictions like the United Kingdom and similarly situated legal systems that follow their model, which does provide copyright protection for works created by a computer, and they give that protection to the person who arranged that work. There are also differing approaches to exceptions and limitations. Some countries have very specific text and data mining exceptions. The pending AI Act in the European Union has transparency requirements mandating the publication of summaries of copyrighted works used in training. Now, that AI Act still has to go through a trilogue negotiating process, but that issue is very live in Europe and elsewhere. If you're interested in diving deeper on these international matters, as I mentioned, we hosted a webinar in July. It's online. It included leading copyright scholars from around the world talking about many of these issues. Our notice also asks, whether approaches developed in other countries should be adopted or should be avoided here. We always have lessons learned to look at. In some, these are still early days, and it remains to be seen how many different national laws will be interpreted in the context of generative AI. So to wrap up, and I'm sure we're going to be hearing more in today's conference, I want to make a public invitation. Please participate, share your views to our docket. We have extended the deadlines for October 30th. for initial comments and November 29th for reply comments. To be clear, you do not have to answer all the questions. Don't be intimidated. We are going to be reviewing all the comments that we received to this notice, and we are going to be using our human eyes. Our team is going to be doing this. Right now, we have almost 8,000 comments that are on regulations.gov. We're also monitoring developments around the world, as I mentioned, but also developments in the marketplace. There's a lot of news that keeps changing and being reported every day on how these companies are either coming up with contractual agreements, changing terms of ingestion, people buying other companies. There's a lot going on in the marketplace, and that is often instructive as to what can the private marketplace produce and contribute in positive ways to these complex legal issues. And so as for next steps, we're looking to update our compendium for practices, update our registration guides for applicants. We plan to produce one or more reports with analysis of legal issues and recommendations for any possible desired legislative or regulatory change. I don't have any expected dates of when we're going to release this, but I can say it's not going to be this year. And with that, I want to thank you for your attention. I look forward to your questions, and thank you for having me participate. Thank you very much.
All right. Well, a tour de force of the vexing issues at the intersection here. So it is a Silicon Flatirons tradition under the Phil Weiser rule, our former director, that the first question goes to a student. And I see a couple of my students parked down here. I made all my copyright students come today. So I hope we'll get a volunteer, but cold calling is a possibility, of course. All right. Question from a student.
There we go.
And if you could wait till the microphone comes down and introduce yourself so the folks online can catch us, that'd be great.
Thank you. I'm doing this to avoid a cold call. Thank you so much for being here. I'm wondering if you could speak a little bit if you have looked at the comments that are coming in. Are the majority of those, what is kind of the breakdown? Are they coming in from lawyers? Are they coming in from creators? I know lawyers are probably more likely to be familiar with the process, but I'm interested to know who is speaking on this as you're compiling these comments.
Yeah, no, thank you for that. So what we do is we use another government agency system called regulations.gov, and that's where all the comments will get funneled to. And like I said, we have almost 8,000 right now. Right now, we're going through them to make sure that there's no errors. Like sometimes you can click a box and say your one comment was 10,000 comments, and that kind of makes the number go crazy. We're looking mostly to make sure that we're going to be able to hit post when the day comes, or the day after the deadline. I will say right now, based on our preliminary review, no, most of the comments we have received so far are individuals. If I were to outline a trend so far, it's mostly creators who are very concerned about AI, maybe upsetting their livelihood. I don't want to venture a conclusion, but I will note that many of these folks are also participating in various strikes involving the motion picture industry. And so I think that's part of it. But, to the extent individuals, contribute a major part to the creative economy, this is exactly the kind of thing we want to have. We do expect that the number will increase exponentially as we get closer to the deadline with more formal, comments from whether it's academics, trade associations, companies, small companies, more individuals. We do get, and I do expect in this docket, a very wide variety of interests. I think it's really important to keep in mind that, as I said earlier, it's not binary, it's not content, it's not tech. It's never been that. And so it's, people who are large companies have different views than people who are small companies. And so we expect to see a robust round of comments. And like I said, I don't want to venture against how many more thousand more we will get, but we are going to do our best to get them posted so that everyone can review them. And then if they wish, provide reply comments. I have spoken to other countries around the world, and they are looking at this very closely, because it will be a public repository of a state and time at the end of 2023 where, the public sees this. So please look. Thanks.
I'm tempted to follow up and ask whether you're going to get any comments from artificial intelligences and how they'll be received by the office. I don't want to put you on.
Yeah, we think we've seen a couple, just a very few. They will count. Yeah, we're not going to be doing any kind of registration examination of comments, but I do expect that. I mean, in prior dockets, we have seen grassroots campaigns, foreign letters, and that's fine. But I do expect probably to see some. We'll find out.
All right, open it up to the audience for questions, and someone standing right by a mic.
Thanks so much. Dan Murray, Rocky Mountain AI Interest Group. We did have Jason Allen speak at our group, the author of the theater opera spatial image you mentioned. So I have a question, like the current approach on copyrightability of AI generated images. If someone generates the image with an AI tool like DALL-E 3 or Midjourney, and then changes it, like let's say they bring it into Photoshop and they make changes that are not de minimis, is the copyrightability then that you apply for copyright of that image and disclaim the parts that are AI generated? Is that the current approach? That's what I don't understand.
Yeah, you need to disclaim the part that is more than de minimis. So when we looked at Mr. Allen's original Midjourney thing, we found that there was a lot of AI generated material there, and that's what he needed to disclaim. He chose not to disclaim it, and that's why we had to, refuse his registration. But we also would note, and I'm not going to get ahead of our registration department, but if you take a look at certain parts of the image that he submitted for registration, there is arguably some pretty creative things that he did in other sections of that image. And that's why we said if he wanted to get at least the copyright in that part of the image, he would need to file a new registration so that our examination folks could do that. So this is the exact problem of, what's the difference between AI generated and AI assisted? Because many industries, I mean, music, just think of music. There's been a lot of artificial intelligence, computer-generated things that assist in the creation of music. Same thing in art. I mean, Adobe Photoshop. There's a lot of tools out there that are done at the initiation and the control of a human. And so back in 1965, our office actually recognized that, we don't have an absolute rule saying no. We're looking for, and I think I can quote, whether the work is basically one of human authorship or whether the computer or the device merely assisting an instrument. But what we're looking for is the traditional elements of authorship that were actually conceived and executed not by man, but by a machine. So that is also a question of our inquiry. And that's why we're trying to make those decisions and get better guidance on that, because things keep changing. So back to your point, if Mr. Allen, wanted to resubmit after he disclaimed the non-AI part, our registration team would take another look.
Come down to Professor Braca in the front row.
Thank you, Oren Bracha, the University of Texas here. So again, about authorship. I wanted to ask you the following. There is this argument out there that in some cases, a human can establish authorship simply by virtue of the creativity of the prompt. So to be clear, it's not a case of selection and arrangement of AI-generated materials or adaptation in any way. The claim is sometimes the prompt itself, if rich and creative enough, makes the human who just created the prompt the author of the work, whether because of the richness of the prompt or some reiterative process. Does the office have any position on that? So
I will say that is a question in our NOI, but I would point you to both the Zaria of the Dawn as well as the Teatro Spatial letters, where we took administrative notice of how Midjourney works. And so if you take a look at those opinions, we stayed based on the examination of those works, realizing other works might be different, that the prompt was merely an instruction. It was not done by the human. And I think, again, right now, if you take a look at the technology, I'll use Midjourney as an example, there is always going to be an unpredictable nature of the output. You could prompt away, And even the folks who are behind the algorithms themselves have said, we're not quite sure how you get to that last output. So if that's the case, the machine did the output, not the human. So, but I will also agree with your question that we would welcome further input on the prompt question, because I think that is something we're going to have to definitely be looking at. Thanks.
So we go to the question in the far back.
That was really interesting. Thank you. And my name's Steve Heuser. I work for Politico, and I have more of a Washington tech policy type question. Your Copyright Office is part of the Library of Congress officially, right? So on these topics, are you all getting guidance directly either from Congress or even like from the White House on this? And if you're not, what kind of guidance would you like to see? If you are, what is it?
We are in the Library of Congress. We are in the legislative branch. Congress, as I showed you, has directed us. We are their primary guidance and advisor on the law. So I can pick up the phone and talk to a staff member, represent my agency and give them impartial legal advice for the question they want. If you're in the executive branch, let's say the Patent and Trademark Office, Department of Commerce, any of these other groups, what they usually have to do is you have to go through your government relations team in order to talk to Congress, because that's sort of the procedure, right? Because the executive branch needs to come together. They have a lot more cross-agency coordination because they want to speak on behalf of the executive. And there's a lot of executive branch agencies. So does the executive talk to Congress? Sure, they do. But I think the initiative that we have right now is being led by the Copyright Office. I have a lot of colleagues who are on the copyright team at the Patent and Trademark Office, and we're keeping them informed of the work we're doing. But the legal analysis and the ultimate conclusions will be the work of our office.
All right, we've got a question in the third row over here.
Hi, so I'm intrigued by the big difference between the US and the UK's view. And I guess I have two questions. One, does that reflect sort of an historical distinction between the two countries and how they view copyright? And my second question is, who's the outlier here globally, the US or the UK?
On the first question, obviously our legal tradition comes from a lot of, statute of Anne, there you go. But yeah, the provision that they have in terms of the computer work, that's been there actually for quite some time. So I think they are still trying to find a way to use it, because my understanding up until recently, it hasn't really been a big issue for them. They are taking another look at it. I believe there's similar provisions in, I want to say Australia, maybe New Zealand as well. In terms of an outlier, I will say that the really interesting part about copyright law, it's national. There's a lot of themes, but the actual way in which laws are written and definitely interpreted varies territory by territory. I would say that there's some discussion on what, if any, kind of new right might be needed to address this kind of situation. There's been some in the academic world who have suggested that maybe a sui generis right might help solve this AI thing, much like the database work in the EU did. I think I'd like to hear some more analysis on that. I think the outlier, it's not that the UK doesn't respect authors, it's just that they have this additional subsegment. I think that most copyright offices right now do heavily believe that human authorship is a very important element. I think it goes back to the Berne Convention. I mean, Victor Hugo, Les Miserables fame, helped create the Berne Convention. There weren't computers back then, and they were very much interested in protecting, the artistic rights of authors. So I think the human authorship element is going to stay pretty firm. I think where the development might be is to the question you meant, and I wouldn't use the word outlier, is what, if anything, is there going to be another way to address this? And then that question raises the next issue is, if you, country over here, have a sui generis protection for, let's say, some kind of AI assisted or AI generated work, and I'm a country over here that doesn't recognize that, this person becomes the outlier because their work can't be protected over here. So there's a big challenge there if you're looking at trying to find a common understanding across nations. That is going to be a major challenge. Long answer, sorry.
I think we've got time for one or two more questions. Why don't we go right back here?
So I think one thing that's interesting is, so I'm a lawyer, work at Red Hat, and the lawsuits that are getting the most attention and what everyone obviously has talked about, which is understandable, is like the sort of visual arts, right? It's a lot easier for us to grasp. But there is a lawsuit, of course, against Copilot and GitHub. And I think like with my lawyer hat on, right? It's like, well, these are all things that are protected by copyright code and paintings and, everything else. However, there's something like visceral from a human perspective in a difference, right? I mean, arguably, even though source code's protected by copyright, has a lot more usefulness than, what we think of as sort of art. No offense to any of my developer friends. I think they would agree with that. So I was just curious if it sort of cuts, I think, to that final question and then starts to bleed into what I would say maybe even the moral rights kind of protection, which we don't have here. So I was just wondering if one of the things I've wondered, and I don't know if you can say this, but like, is if we will end up with a splicing, if you will, of sort of how much protection is for different types of works that are generally lumped together.
Yeah, I mean, I think that the issue of looking at name, image, likeness, style is, and whether rights of a publicity or misappropriation at the federal level is very much a live one. There's been interest on both sides, both the House and the Senate, on that based on the recent hearings. The question would be, could such a law be developed at the federal level, and where would it live, right? I would bet or guess it would probably not live in the Copyright Act, but in the US Code. I think that's possibly the way things are going to go, but there's a lot of challenges there, right? I mean, copyright also builds on style. I mean, is style the right word? I think it's different. I think it's going to be more likenesses because there is as you mentioned, a very visceral image or a visceral reaction to an artist or a singer or an actor who wants to be, not only credited that their name is associated with their work, but, have the right to control people who use that. So I think that area, also is very important for the issue of deep fakes, election, false advertising, which is, again, being raised in Congress as well. And so I think, I'm not going to predict, but I think you can see that I think there's a train going towards that direction on the Hill. Yeah.
All right, noting the time, I'm sorry because I see a lot of hands up. I'm going to have to invite us to continue this conversation next door at the reception. So we'll come to our first break now. We'll reconvene in 15 minutes, so 10:15 Mountain Time, and we will see you back. But please join me in thanking Associate Registrar Sean.